Trial resumed. Jury not present.
The court said, "Good morning. Please make your appearances."
Mr. Horton said, "Good morning, Your Honor." Justin Horton, Micah Ferguson, Juliana Murray, and Ryan Finkel. For the United States.
Mr. Skirek said, "Good morning, Your Honor." Scott Skirek, Siddhartha Kumraju, and Matthew Barkin, for the defendant. Mr. Gua, together at counsel's table with Mr. Gua.
The court said, "Please be seated." On June 25, 2024, the parties submitted their proposed revisions and additions to the court's draft jury charge. Yesterday, July 7, 2024, the government filed a letter requesting additional revisions. I also received a letter from the defense at 12:13 a.m. today. I will address each of the parties' proposed edits in the order they appear in the jury charge that my law clerks have just provided to you. Starting on page 6. In the first paragraph of the burden of proof and presumption of innocence section, this also applies to page 14 in the first paragraph of the summary of indictment section. The government requests that the court add language stating that the government is not required to prove every allegation in the indictment, but instead only the elements of the charges. The defense does not oppose the addition of this language. I will add the requested language to the burden of proof and presumption of innocence section, but I will not repeat it in the summary of the indictment section. On page 13, in the second paragraph of the section titled Government as a Party, the government asks that I add the words United States to the sentence beginning, "This case is important to the government," which I will do. In the following paragraph, which begins with the fact that the prosecution, the government requests that I include the following language. This prosecution was lawfully brought by the United States of America, and the decision to bring this case was in no way influenced by the Chinese government or the Chinese Communist Party. I do not believe these sentences are necessary. The evidence thus far has not left the jurors with the impression that the prosecution was unlawful or influenced by the CCP. On page 14, in the first paragraph under 14, Summary of the Indictment, the government requests that next to the defendant's name, I include that he is also known as Ho Wan Kwok Guo Wan Gue, Brother 7, the principal and boss. I will include that Miles Gua is also known as Ho Wan Kwok and Guo Wan Gue. In the last paragraph on page 14, which begins with "the indictment contains," and on page 15 in the second paragraph, which begins with "in a moment," the defense requests that I include the words "against the defendant" after 12 counts. Because the indictment contains one count against Mr. J alone, I will include the defense's language. On page 15, paragraph 1, the government requests that the phrase "lifestyle membership company known as G Clubs" be revised to "purported online membership club known as G Clubs." The government states that this tracks the language in the indictment. At this point, I do not believe that the additional descriptors are necessary and shall simply state "in connection with G Clubs." Page 15 contains a sentence in paragraph 2 stating, "Each count constitutes a separate crime." I grant the defense's request to add the word "alleged" in between "separate" and "crime." On page 16, in the second paragraph under 16, Elements of Wire Fraud, in the last full sentence which begins with count 9, the government requests that the phrase "how their membership dues would be used" be revised to the more neutral description, "how the money individuals sent to G Clubs would be used." I will make this revision. In the same paragraph, in a subsequent sentence, the government requests that the phrase "how the funds raised would be used" be revised to "how the money sent to the Himalaya Exchange or spent on its credits would be used." The clause beginning with the word "or" is duplicative, so I will state "how the money sent to the Himalaya Exchange would be used." On page 17, the third full paragraph, and page 19, paragraphs 5 and 6, the government contends that "willfully" is not an element of the wire fraud statute and requests its omission throughout. As authority, the government cites Judge Oatkin's decision in United States v. Middledorf 18 Cr. 36, as well as an Eastern District of New York case. But in Middledorf, although Judge Oatkin rejected the instruction from the Sand Treatise, he still gave a willfulness instruction. Other judges in this district have done the same. See United States v. Bankman-Fried, 22 Cr. 673, United States v. Avenatti, 19 CR 374, and United States v. Constanzo Riccio 22 CR 281. The Second Circuit has not explicitly disavowed the willfulness element. See United States v. Petrossi, 786 F. Apex 286, 289, 2DR 2019. However, the definition of willfully in my first draft of the charge implies that the defendant needed to know that his action was unlawful as opposed to, more generally, wrong. Accordingly, I will amend the definition which appears on page 19 in the fourth and fifth paragraphs of the section titled B. Second element, knowledge and intent to defraud to state. To act willfully means to act voluntarily and with a wrongful purpose. An act is done knowingly and willfully if it is done purposefully and deliberately. This accords with the more limited instructions that other judges in this district have used, as well as the Second Circuit's decision in United States v. Kaiser, 609 F.3d 556, 567-68, 2DR 2010. On page 17. In the first paragraph under A. First element, scheme to defraud, the defense asks that I state that a scheme or artifice is a plan to accomplish a fraudulent objective. The proposed addition of fraudulent is incorrect and I will not include it. In the last paragraph on page 17, the defense asks in addition to stating that a statement is fraudulent if it was made with intent to deceive, that I also state that the intent to deceive must exist at the time the statement was made. This addition is not necessary because it is redundant and I will not include it. On page 17, after the first full paragraph in the section titled A. First element, scheme to defraud, the government asks that I include a paragraph stating, it is not necessary that a false or fraudulent pretense, representation or promise be made prior to a victim's decision to part with money or property. Rather, if after having obtained money or property the defendant devises or participates in a fraudulent scheme to keep that money or property by making a subsequent false or fraudulent representation as to a material fact, that is sufficient to establish the existence of a scheme to defraud. I do not agree that this instruction is necessary or helpful, and will not include it. On page 17, after the last full paragraph, the defense requests that I include a paragraph stating, fraud requires more than simply proof that a promise was made and then not fulfilled. Failing to maintain a promise or to abide by a term in a contract or other document is not by itself fraudulent. Instead, the government must prove beyond a reasonable doubt that the defendant, at the time they made the statement or promise, never intended to honor. A subsequent decision by a defendant not to abide by the terms of a promise, contract, or document, even one that is willful, cannot be the basis for a conviction. I do not agree that this instruction is necessary or helpful, and will not include it. On page 18, paragraph 1, the third sentence states, that means that if you find that a particular sentence was false, you must determine whether that statement was one that a reasonable person might have considered important in making his or her decision. The defense requests that might be changed to would. I will make this change. After the third that, the defense also requests that I include the clause, was capable of influencing the decision. The addition of that language would confuse the jury, and I will not include it. On page 18, before the paragraph that begins with in determining whether a scheme to defraud exists, the defense requests the insertion of a new paragraph that states, to establish a scheme to defraud, the government must prove beyond a reasonable doubt that the defendant contemplated depriving another of money or property. It is not enough that some other person or company could have acquired money or property. To prove the scheme to defraud element, a defendant must have contemplated actual harm would befall victims due to his deception. A scheme to defraud need not be shown by direct evidence, but may be established by the circumstances and facts in the case. This paragraph duplicates the intent element, and I will not include it. On page 19, in the second to last full paragraph, the defense requests that I rephrase the intent to defraud definition as follows. Put differently, to find specific intent to defraud or fraudulent intent, you must find that the defendant had the intent to cheat or steal money from others at the time the misrepresentation or false promise was made. I do not believe that this rephrasing adds clarity and will not include it. On page 20, the government requests that I include two instructions stating that 1. A defendant's belief that no ultimate harm would result is not a defense to fraud, and that 2. A defendant need not be solely motivated by fraud. I agree that these two instructions offer important clarification, and shall include them. I will state at the end of the second full paragraph on page 20. Additionally, it is not necessary for the government to prove that the defendant was motivated solely by improper considerations. The defendant may have the required intent to defraud, even if the defendant was motivated by other lawful purposes as well. Also on page 20, in the last paragraph in the instruction on good faith, I will state, however, in considering good faith, the fact that a defendant believes, rightly or wrongly, that he will ultimately be able to work things out so that no individual suffers a loss, is no excuse for the real and immediate loss resulting from the defendant's fraudulent conduct. The government requests the addition of the following language to the no ultimate harm instruction, arguing that it is necessary to address testimony about the Himalaya exchange. They would like me to state, nor is it a defense that certain people were offered or received refunds. Whether any of the companies involved continued to operate is also not a defense. I believe that the no ultimate harm instruction is sufficient as is, and will not include the proposed language. The government requests that the court add the following language at the end of the final paragraph on page 20. All of that said, you have heard evidence that Miles Gua and certain of the entities in this case had lawyers. A lawyer's involvement with an individual entity or transaction does not itself constitute a defense to any charge in this case. The defense has not claimed, and it cannot claim, that the defendant's allegedly unlawful conduct, as charged in the wire fraud counts, was lawful, because he engaged in such conduct in good faith reliance on the advice of lawyers. I'm going to add a new section under V. Final General Instructions, titled 31. Involvement of the lawyers. The section will read as follows. You have heard evidence that the defendant and certain entities were represented by attorneys. A lawyer's involvement with an individual or entity does not make that individual or entity's actions legal. Following the final paragraph on page 20, the defense requests an additional paragraph stating, if you find that the defendant was not a knowing and willful participant in the scheme or lacked the required intent to defraud at the time of the operative false statement or false promise, then you should find the defendant not guilty. On the other hand, if you find that the government has established beyond a reasonable doubt not only the first element, namely, the existence of the scheme to defraud, but also the second element, that the defendant was a knowing participant and acted with specific intent to defraud, then you should proceed to the third element. I do not agree that this paragraph is necessary, and will not include it. On page 21, in the third element section, the government asks for a clarification that a wire communication can be made after the relevant funds were obtained. The government requests this specific language. A wire communication can also include a communication made after an individual's funds were obtained if the communication was designed to lull that person into a false sense of security to postpone his or her complaint to the authorities, or to keep the money obtained from the scheme. I shall include a portion of this language. But I do not believe that the examples cited by the government are necessary. Accordingly, I will state at the end of the second full paragraph on page 21. A wire communication can also include a communication made after an individual's funds were obtained. On page 24, the defense asks that I include at the end of the first paragraph in the materiality subsection the following sentence. Expressions of corporate optimism and puffery are not material. I reject this addition as confusing and unhelpful to the jury. On page 24, after the second paragraph in the materiality subsection, the defense requests that I include, however, you may not assess materiality from the perspective of hindsight, nor is a misrepresentation material simply because it may have been important to an investor. I will instead add the following sentence at the end of the first full paragraph on page 24. Materiality is judged as of the time the information was disclosed. The second proposed sentence, which aims to distinguish between importance and materiality, is needlessly confusing and I will not include it. The definition of materiality is sufficient and does not equate materiality with mere importance. On page 24, in the charges definition of a security, The defense proposes the addition of a paragraph that provides a separate definition of a security if the government takes the position that the farm loans and G Club memberships are themselves securities. I do not understand the government to be taking this position. Am I correct?
Mr. Horton said, "If I can have 1 second, Your Honor."
The court said yes.
Counsel conferred.
Mr. Horton said, "That's right, Your Honor."
The court said, going to page 25. In connection with section, the defense requests the addition of the following paragraph after paragraph 2. However, the in connection with element is not met simply because an alleged fraud happens to involve the sale of securities. It requires something more. The government must prove beyond a reasonable doubt both that the deceptive conduct coincided with particular securities sales, and that the deceptive conduct was material to the investor's decision to buy particular securities. If the alleged deceptive conduct did not coincide with a particular sale of the securities, then the in connection with requirement is not satisfied. In addition, if the defendant's alleged misrepresentations did not concern the value, nature, or investment characteristics of the securities, then the in connection with requirement is not satisfied. Moreover, alleged misrepresentations that occurred after a security sale cannot have coincided with such purchase or sale and, therefore, cannot have been material to such sale. I reject the proposed language. First, finding that deceptive conduct coincided with particular securities sales is only one way of finding that deceptive conduct touches upon a securities transaction. The addition of this sentence would be confusing and could limit the definition. When the Supreme Court and the Second Circuit have espoused a broad interpretation of the phrase in connection with. Merrill, Lynch, Pierce, Fenner and Smith Incorporated v. Dabbitt, 547 U.S. 71, 85.
2006. The remainder of the proposed paragraph imports aspects of the materiality inquiry into the in connection with definition. On page 25, in the first paragraph of the in connection with section, the government requests the addition of the following sentence. It is not necessary that any actual securities be sold or delivered so long as purported securities were offered as an inducement to transact, and promises that someone will receive stock in the future constitute a sufficient connection with a purchase or sale of securities. Based upon this proposed addition, the court will add the following sentence before the last sentence in the first paragraph. Nor is it necessary that any security was ever issued or sold. On page 26, in the first paragraph, the defense requests the addition of the following sentence. Therefore, however misleading or deceptive a plan may be, it is not fraudulent if it was devised or carried out in good faith. This includes the defendant's honest belief in the truth of the representations made by the defendant. I will not include this language, but instead, after the first sentence of that paragraph, I will repeat the following definition of good faith that I provided earlier in the wire fraud section. A defendant acts in good faith when he honestly believed at the time that the representations he was making were true, even if they turned out to be inaccurate or false. Also on page 26, after the first paragraph, the government requests the addition of the following paragraph. In considering whether a defendant acted in good faith, however, you are instructed that a belief by the defendant, if such belief existed, that ultimately everything would work out so that no investors would lose any money does not necessarily constitute good faith. No amount of honest belief on the part of a defendant that the scheme will ultimately make a profit for the investors will excuse fraudulent actions or false representations by him. I will not include the proposed language, but will repeat the following instruction that I provided in the wire fraud section. However, the fact that a defendant believes, rightly or wrongly, that he will ultimately be able to work things out so that no individual suffers a loss is no excuse for the real and immediate loss resulting from the defendant's fraudulent conduct. The government at the end of that same paragraph again requests an instruction regarding lawyers' involvement with the defendant and related entities. Because I have now added the involvement of lawyers' instruction, I will not include the instruction here. On page 34, in the second element, participation section at the bottom of the page, at the end of the paragraph that begins with, "It is not necessary for the government," the defense asks that I add the following two sentences. If you find that the defendant did not have a financial interest in the outcome of the scheme, that is also a factor you may properly consider in determining whether or not the defendant was a member of the conspiracy. Ultimately, the defendant's participation in the conspiracy must be established by independent evidence of his own acts or statements. I will add the following sentence to the end of that paragraph. Conversely, if you find that the defendant did not have a financial interest in the outcome of the scheme, that is also a factor you may properly consider in determining whether or not the defendant was a member of the conspiracy. On page 36, paragraph 1, I grant the defense's request to omit the word "also" before co-conspirators of the defendant in the second full paragraph. On page 50, the government asks that I refrain from characterizing the RICO count as complicated, which I will do. On page 51, in the second paragraph of the subsection titled A, first element, racketeering enterprise, the defense asks that I delete the sentence. Of course, proof that the objective of the conspiracy was accomplished, if you find that it was, may be most persuasive evidence or the most persuasive evidence of the existence of the conspiracy. This is a standard conspiracy instruction that I believe is helpful to the jury, so I will not omit it. On page 52 in the final two paragraphs and page 58, paragraph 1 of I, Enterprise versus Pattern of Racketeering Activity, the defense asks that I specify that G enterprise is a term used by the government, which I will do. In the final paragraph on page 52, the defense asks that I rephrase the first component of finding a RICO enterprise to state a common purpose to conduct a racketeering enterprise instead of only a common purpose. I do not agree that that is a correct statement of the law, so that edit is rejected. However, I shall rephrase the last clause to state that then you may find that the first element of a racketeering conspiracy has been satisfied, rather than suggesting that the whole crime has been proven. In that same paragraph, the government asks that I include the phrase, during a substantial period within the time frame charged in the indictment, after a continuing unit. The charge already includes substantially similar language on page 52 in the first full paragraph on that page, and I do not agree that the additional language is necessary. On page 55, in the first paragraph under fourth element, Pattern of Racketeering Activity, the defense asks that I move the sentence beginning "the government must prove that the defendant agreed" to earlier in the paragraph. I will do so. In that same sentence on page 55, the government asks that I clarify that the defendant is also responsible for the acts of agents committed within the scope of their agency. The government's proposed sentence reads, the government must prove that the defendant agreed to participate in the enterprise with the intent that he or another member or members of the conspiracy or their agents commit two or more racketeering acts which I will describe. I believe that this instruction will confuse the jury and I will not add it. On page 56, in the third full paragraph which begins with "First," the government asks that I give examples of types of racketeering crimes after the underlined sentence. I think that this is helpful and will add the government's suggested language to the end of that paragraph. On page 57, at the start of the second full paragraph, the government asks that I delete the statement that a substantial period of time is at least 2 years. I will omit the 2 years language, which, although the circuit has never approved a shorter period of time, is not a bright line rule. However, the government's suggested language is also likely to confuse the jurors. I will follow the model of other RICO conspiracy charges and omit an explanation of substantial period in the charge. The defense asks that I delete the conscious avoidance instruction. This instruction may only be given if there is evidence that 1. The defendant asserts the lack of some specific aspect of knowledge required for conviction, and 2. There's evidence that the defendant was aware of a high probability of the fact in dispute and consciously avoided confirming that fact. United States v. Ferrarini, 219 F.3d 145, 154, 2d CIR 2000. I find that these requirements have not been met and I will omit the instruction. The defense asks that I add a multiple conspiracies instruction. I will not include such an instruction. The multiple conspiracies charge is designed to assist the jury in determining whether or not a particular charged conspiracy was truly a single conspiracy, not to remind them separately to consider each charged conspiracy. United States versus Aguilar, 352 F. Apex 522. 525. 2D SIR 2009. It appears that the defense wants me to emphasize that the conspiracies charged in counts 1 through 4 should be considered separately. I believe that a multiple conspiracy instruction would confuse the jury. The charge states on page 15 that the jury must consider each count of the indictment separately, which I find sufficient. Therefore, I will not add the multiple conspiracies charge. On page 62, in the 28. Law Enforcement and Government Witnesses Instruction, the defense asks that I add a sentence stating that it is perfectly appropriate for defense counsel to attempt to attack the credibility of such a witness on the ground that his or her testimony may be colored by a personal or professional interest in the outcome of the case. I find that this is duplicative of the existing credibility of witnesses instruction, and I will not include it. The defense asks that I delete the accomplice/cooperating witness testimony, immunized witness, and similar acts instructions as inapplicable. The government does not object, and I agree that they should be excluded. On page 64, the defense asks that I add language to the non-prosecution agreements instruction, stating that a witness testifying under an NPA should be closely scrutinized. I will omit the sentence that states, "It may not be used by you in any way for or against the defendant," which I agree may be confusing, and I will add a sentence to the end of that paragraph stating, "Of course, you may consider whether the fact that the witness entered into this agreement affects the credibility of their testimony." The defense requests an instruction that the fact that the charges in this case may have involved large sums of money does not mean that the defendant is held to a greater standard of conduct. I do not agree that this instruction is necessary or helpful and will not include it. The defense also asks for an instruction that the jury may not consider Soroka's settlement with the SEC as evidence of criminal conduct. Does the government intend to make the argument that the settlement is evidence of criminal conduct? Counsel conferred.
Mr. Horton said, "Your Honor, the answer is no. It is a relevant fact in the narrative. But the answer to the court's question is no."
The court said, "The government asks that the jury be instructed that the defendant has not raised a duress excuse or justification defense. I don't see that the defense has implied this thus far. Accordingly, I will not give this instruction. My law clerks have provided you with a copy of the verdict form. Finally, in preparation for deliberations, the parties are reminded of my May 7, 2025 order concerning the provision of exhibits to the jury. For jury deliberations, the party shall provide a clean laptop containing only the exhibits admitted into evidence. The laptop must be prepared prior to the start of deliberations, and the party shall also provide the required cables to connect the laptop to the monitor in the jury room. During summations, if either party believes that there has been a clear misstatement of a fact or misstatement of the law, certainly you may object. And if you feel that a sidebar is necessary, you may request that. But I want to keep that absolutely to a minimum because that interferes with the flow of the attorney's summation. I'm now going to go to the issue regarding the testimony of Mr. Dragon. By letter dated July 2, 2024, the government moves to strike a portion of defense expert Raymond Dragon's testimony from earlier that day, ECF number 389. The government raised two issues. The first issue, which concerned the interpretation of Dragon's testimony concerning very large investor interest, was resolved by agreement of the parties on July 3, 2024. See transcript at page 5032, lines 1 to 17. As to the second issue, I directed the defense to respond to the government's motion by July 5, 2024. Mr. Dragon testified that $200 million of new GTV shares were sold in the GTV private placement. During his testimony, which appears on page 4893 of the transcript, Mr. Dragon stated that Soroka sold some of its own GTV shares as part of the GTV private placement, which resulted in the sale of $350 million of GTV shares. exceeding the $200 million of shares initially advertised in the GTV private placement memorandum. The government contends that Mr. Dragan has no personal knowledge that Soraka was the source of the excess shares, and that this information was not in any of the materials that Dragan disclosed as having reviewed. By letter dated July 5, 2024, the defense opposes the government's motion, stating that Mr. Dragan's understanding is based on the GTV private placement memorandum, which is in evidence, ECF number 390. The defense states that because the private placement memorandum discloses Soraka's ownership percentage of GTV as 100%, Mr. Dragan reasonably concluded that any excess shares beyond what the GTV private placement initially sought to sell would necessarily come from Soraka's equity holdings. ID at 1. I'm satisfied with the defense's explanation of Mr. Dragan's testimony, which the government had the opportunity to probe on recross-examination. Accordingly, the government's motion to strike is denied. We are missing juror number 4. Oh, I'm sorry, juror number 10. She says that she is experiencing nausea and diarrhea, that she consulted a doctor who told her to stay home and take certain medication and rest. How would you like me to handle this?
Mr. Horton said, "If we could have just one moment, Your Honor."
The court said yes.
Counsel conferred.
Mr. Horton said, "Thank you, Your Honor." Given the number of alternates available, the government proposes that we move forward with the trial.
The court said, "Does the government believe that I have the discretion to substitute the alternate without the consent of the defense?"
Mr. Horton said, "Yes."
The court said, "I'll hear from the defense."
Mr. Kamraju said, "Thank you, Your Honor. First of all, I do believe, and I think this has come up before, that the court has the discretion to excuse the juror and impanel an alternate, even over the defense's objection. We recognize that the trial needs to move along. But we do think that it's possible that not giving one of the jurors a sick day, in essence, could constitute an abuse of that discretion. Particularly given that we have now reported that Mr. Gua does not intend to testify, and so that, I think, relieves some of the time pressure. So from our perspective, it is certainly within the court's discretion to do so if it believes it's appropriate to move it along. We do think that creates a risk."
The court said, "So although I don't believe that substituting the alternate would be abuse of discretion, I'm having my clerks look at that question in an abundance of caution. In the meanwhile, I have some questions for Mr. Gua. So Mr. Kamraju, you have said that Mr. Gua will not be taking the stand. Is that right?"
Mr. Kamraju said, "Yes, that is our belief at this time, Your Honor. He's not planning to take the stand. I just want to be clear that he does have the right to change his mind at the end of the defense case. But he does not plan to take the stand."
The court said, "Okay. So you understand, Mr. Gua, that you have the right to take the stand and testify in your own defense?" The defendant, "Yes, Your Honor. Saturday and Sunday, the attorney Kamraju and Sabrina has discussed this with me, and I made my decision of not testifying." The court said, "And are you satisfied that your attorneys have spent enough time with you and answered all your questions about their advice concerning whether or not you should testify?" The defendant, "Yes, Your Honor." The court said, "And you understand that the decision whether or not to testify is yours and yours alone?" The defendant, "Yes, Your Honor." The court said, "So am I correct that you on your own have made the decision that you do not want to testify?" The defendant, "Yes, Your Honor." The court said, "All righty. So moving forward, I'm looking for simultaneous translation. Are there any other issues that the parties would like to raise at this time?"
Ms. Shrofa said, "Your Honor, we did have an issue with the translation. The witness who was on the stand described the experience as having to parse out information as though he were in the middle of a playground and many voices were being heard all at the same time. Over the weekend, I did reach out to the interpreter's office to try and resolve this because the witness was. This is exactly how the witness described it. Like being on a playground having to parse through many voices. So I asked the court to consider allowing consecutive translation for the witnesses, which I think is the norm. But if not, I guess it will have to be what it will have to be. But he did describe the experience that way. and I raised it with the interpreters.
The court said, "Does the government wish to be heard on this question?"
Ms. Murray said, "Your Honor, I think on this point we would defer to the court. We would note the witness seemed able to answer the questions that were posed during the 2.5 hours of direct examination we've had so far."
Ms. Shrofa said, "The witness described the experiences exactly the way I recited it." I then reached out to the interpreter's office. The reason I called for a side break is because throughout the testimony he kept tugging at one ear and had difficulty with the number of voices going in. So as I understand it, he's not just listening to the English, which he's partially fluent in. Then he's listening to one interpreter and at the same time the English voice is continuing. So there's an overlay. Whether or not he managed to make do for 2 hours isn't the point. I've just laid out what the witness said. Your Honor, that's all. Thank you.
The court said, "So my strong impression was that he fully understood the questions. He did not protest at that time about the simultaneous translation. There was a point at which he said that there was maybe a problem with one of the earphones, but he also stated that it had been corrected. In my 24+ years on the bench, I've always had simultaneous translation. That is the norm. Anything further?"
Ms. Murray said, "Just a few brief points, Your Honor. With respect to the witness who was on the stand at the end of the day Wednesday. The government yesterday received 26.2 materials from the defense which indicated that they met with him this weekend. Yesterday, and prepared him. We would note he's in the middle of his testimony. The court has advised every witness in this case up to this point that they should not discuss their testimony. The defense team is certainly well aware of that rule, that order.
By the court. And so we just wanted to raise for the court's attention we don't know the content of that prep. It simply indicated that there was a prep session. But we think it's important to note for the court.
Ms. Shrofa said, "Your Honor, may I have a second?"
The court said yes.
Counsel conferred.
Ms. Shrofa said, "Your Honor, I believe the rule is that if the witness is on direct, he's free to talk to whoever is taking his questioning. In any event, we did not discuss any part of his past testimony. The rule is when he's on cross. I think that's pretty clear. But, in any event, I've conferred and we had no discussion at all with any of his past testimony."
Ms. Murray said, "Would just note, Your Honor, the government has taken the approach consistent with the court's instructions throughout this entire 5.5-week trial that we have not spoken with any of our witnesses, even if they were on direct testimony. We have taken the court's request that the witness not discuss their testimony at its word. And we have not prepped witnesses when they have been on direct either over a break or over an evening or over the weekend during the entire trial."
The court said, "So, Ms. Schroff, are you providing me with a particular rule in the rules of evidence or?"
Ms. Shrofa said, "No, I think that's the general rule. But, in any event, we did not discuss his testimony."
The court said, "Okay. I'm glad to hear that, and I will have my clerks look into that rule. This is the way that I've been doing it."
Ms. Shrofa said, "Just to be extremely clear, we certainly did not give him a copy of his prior testimony. We did not. I personally didn't even review it, if that matters to the court. I did not go back and read the transcript. And I say that to you as an officer of the court. I did not open it. I did not download it. I didn't do anything with it."
The court said, "All righty."
Ms. Murray said, "Your Honor, just based on the 26.2 materials, I don't believe Ms. Schroff met with the witness. Unless the materials omitted the presence of somebody, we believe it was other members of the defense team. But just another note. One other thing I would like to note for the court. Just with respect to the timing of certain exhibits the defense has produced. The government received exhibits for Leanne Lee, who is a witness who is expected to testify at approximately 1 a.m. on Sunday. Those include a number of exhibits that have Mandarin translations the government has not yet been able to verify. We're going to have various hearsay objections and relevance objections to those exhibits, which are WhatsApp chats that are clearly hearsay out-of-court statements of Mr. Gua or of the witness that are being offered for their truth. In the government's view, we just wanted to note the timing issue. They produced additional exhibits for Ms. Lee at 4 a.m. this morning. And again, she's expected to testify today.
The court said, "All right. So that is what you call sharp practice. You do not produce exhibits so late that this is when you expect people to be asleep."
Ms. Shrofa said, "Your Honor, there was a problem yesterday. Once the government reached out, we sent them a chart of what we anticipated using. Mr. Skirik and I were together at the office where there was an actual human and computer problem that caused the delay."
The court said, "What kind of a human and computer problem caused the delay?"
Ms. Shrofa said, "Your Honor, may we just have a sidebar on this?"
The court said, "I want you to give me the explanation now."
Ms. Shrofa said, "The person who was working on it couldn't put it together. The person couldn't put it together and had to take a break, and so that delayed it."
The court said, "Okay. I've told you before that you need to have enough people on your team who are competent in order to handle the trial. You cannot have somebody who falls apart at a crucial moment. You need steady, stable people."
Ms. Shrofa said, "Your Honor, a large amount of Ms. Lee's exhibits are photographs. We've moved Ms. Lee down on the testifying chain. She's not likely to take the stand. She's the second to the last witness."
The court said, "All right."
Ms. Shrofa said, "That's what happened. There was no sharp practices. We did not purposely delay anything. I think you have 2 lawyers were at the physical location, others were not. And we tried to get the paperwork together."
The court said, "You need to hire competent people. Manhattan is full of them. Full of people who are prepared to carry those types of tasks. Don't let this happen again. Alrighty. I'd like to bring out alternate number 1.
Juror present.
The court said, "Good morning, sir. You may sit down. I just wanted to let you know that you are now going to become juror number 10.
Juror said, "Okay."
The court said, "Alrighty. You may step back inside."
Juror not present.
The court said, "Please have the jurors brought in."
Mr. Skirik said, "Your Honor, may I address just one brief other thing before we bring the jury?"
The court said, "Why are we having this feedback problem?"
Mr. Skirik said, "I think that's taken care of it, Your Honor. I just wanted to mention a couple of things that are relevant to what we expect to be the defense's final witness. Hopefully later this afternoon. The witness's name is George Higginbotham. And he is a former Department of Justice lawyer who pleaded guilty to engaging in a conspiracy to lobby officials in the Trump administration on behalf of the PRC government to extradite Mr. Guo. And as part of the agreement to enter into defense stip 1, with which I'm sure the court is familiar. The Fox Hunt stip, the defense agreed not to call several other witnesses who were related to this conspiracy, as well as other Fox Hunt-related witnesses, and only to call Mr. Higginbotham. We expect Mr. Higginbotham to testify, among other things, that he joined the conspiracy in April of 2017, at the time that he was a lawyer for DOJ. That as part of the conspiracy, Mr. Higginbotham, who lives in Washington, went to the Chinese embassy in Washington in July of 2017 to meet with the Chinese ambassador to the United States. He also traveled to China in September of 2017 to meet with several co-conspirators. And he facilitated the transfer of tens of millions of dollars into the United States as part of the conspiracy. Ultimately, he pled guilty to conspiracy in November of 2018 in the District of D.C. We have not, Your Honor, had an opportunity to, the defense has not had an opportunity to meet with this witness. He is still under a cooperation agreement with the government, with the District of D.C. U.S. Attorney's Office. And his lawyers would not give us access to him, so we have not met with him to prepare him today. And the events at issue date back approximately 7 years. I just want to bring that to the court's attention. And lastly, as part of Mr. Higginbotham's testimony, the defense will enter a stipulation into evidence between the parties relating to certain recordings of conversations between Mr. Guo and a Chinese government official Liu Yanping. And we will read select portions of those transcripts to the jury at the conclusion of Mr. Higginbotham's testimony. I just wanted the court to have this for reference in terms of what we expect from Mr. Higginbotham, again, not having had the opportunity to meet with him or prepare him today.
The court said, "So is there an application?"
Mr. Skirik said, "No, Your Honor. I just wanted to make the court aware of those facts."
The court said, "Very well."
Ms. Murray said, "Your Honor, if I may, just with respect to Mr. Higginbotham, since Mr. Skirrick brought it up. One component of Mr. Higginbotham's situation, as Mr. Skirrick mentioned, is that he had entered into a cooperation agreement with the government. To be clear, he did not enter into that agreement with this office. He entered into that agreement with the Public Integrity Unit and LARS in D.C. We have spoken with the defense. We understand they are not going to elicit the fact of his cooperation agreement. And they are not going to elicit details about things relating to his cooperation with the government on direct. That, in our view, would be inappropriate. They've agreed to that. So that is a component of what we understand to be part of his testimony. With respect to the timing here Actually, one other point on Mr. Higginbotham. As Mr. Skirrick mentioned, he was a DOJ employee at the time that he participated in the entirely separate conspiracy that they are looking to elicit. We assume that they are not going to highlight that fact. We've discussed that with the court at length. That would be inappropriate because it would be intended only to suggest that the front table has in any way something to do with the Communist Party Again, this separate conspiracy to repatriate Mr. Gua, which we've already stipulated to. It's been introduced into evidence a number of times. Mr. Doran, their expert, said that paragraph 7 of Defense Stip 1 adequately summarized the entire case that Mr. Higginbotham was involved with. We understand his testimony is coming in. We will cross-examine him as appropriate. But that fact has been covered. The fact of that 2017 conduct, which predates any of the charged conduct in this case, has been covered. So, again, we assume that the defense won't elicit the fact that he is a DOJ employee and we will object as appropriate. Another component that the defense said that they would not elicit is his sentence in his case. That relates to, again, his cooperation. So to the extent that he received a minimal sentence for his involvement in, again, the separate conspiracy from 2017, they are not going to bring that out on direct. And then the last point I would note. Mr. Skirrick just indicated that he expects to call Mr. Higginbotham today. That suggests to the government that they expect to get through all of their witnesses today, as he is scheduled to be last. We may reserve the right at the break this morning to request that they instead call Leanne Lee last. In light of the late production of these exhibits, including approximately 44 audio files that they produced for this morning.
The court said, Mr. Skirrick, you are not going to elicit testimony about the cooperation agreement or about his sentence, right?
Mr. Skirrick said, Your Honor, we have no plans to elicit that testimony on direct, but obviously, depending on what the government's cross is, reserve the right to raise that, should it become necessary.
The court said, and you're not going to be implying at any point that the government is being manipulated by the Chinese government or the Chinese Communist Party, correct?
Mr. Skirrick said, No, Your Honor. The defense has been clear that we don't plan to make that argument. I would note, however, that it is a fact, a simple fact, that Mr. Higginbotham was employed by the Department of Justice at the time of the conspiracy and at the time that he had the meetings that I described to the court earlier today. And, in fact, it is part of the narrative, Your Honor. Because he was asked to go to those meetings in part because he was an attorney for the Department of Justice. So while we have no plans to make the argument that, Your Honor just described, we would ask for some latitude to be able to elicit the narrative, which is important and is, frankly, just part of the factual landscape here, without placing undue emphasis on it.
Ms. Murray said, Your Honor, we strenuously object to that. The statement of facts in connection with Mr. Higginbotham's guilty plea in the D.C. case make it very clear that he was not acting in his DOJ capacity when he conducted any of the conduct that was the offense conduct. He made it clear when he went to the embassy in D.C. and when he went to visit the Chinese official in China that he was not acting in an official capacity. It is entirely improper for the defense to bring that out as part of the narrative of what happened in 2017.
The court said, You're saying to bring out his employment.
Ms. Murray said, That's correct.
The court said, So I'm directing you to not bring out the fact that he was a DOJ employee. I'm directing you to tell him that he may not volunteer that information. Clearly bringing that up is merely a rather clumsy way of trying to link the prosecution in this case with corruption and the Chinese government.
Ms. Murray said, Your Honor, if I may make one clarification. Because we have had certain discussions with the defense about the protest signs that have been produced into evidence in this case that suggested that the DOJ had been influenced by the CCP. We don't object to one factual question about whether at the time he had been employed by DOJ. If that's what the defense would like to elicit. We would object to any further questioning that would suggest in any way that his employment had something to do with his offense conduct.
Mr. Skirek said, and, Your Honor, Ms. Murray anticipated where I was going to go. To an extent. The government did open the door on this by showing the jury the signs that Ms. Murray referenced. And I believe we had an understanding with the prosecution team that we would be permitted to do what Ms. Murray just described. Again, that goes to the point that I was attempting to make, Your Honor. Which is we have no plan to unduly emphasize this. But it is a fact that he was employed by DOJ. And you know. As Ms. Murray said, we have an agreement to be able to at least elicit that fact, you know, as part of his direct. Again, without unduly emphasizing it or.
The court said, well, is the prosecution asking for some type of a curative instruction?
Ms. Murray said, Your Honor, not at this time, although subject to how the direct testimony comes in, it might be possible. As Mr. Skirek said, we've had certain discussions. We don't have an objection. We understand that the view is that the government might have opened the door to this by showing protest signs that Mr. Guo's enterprise had. You know, posted up against the bankruptcy trustee that mentioned DOJ. A curative instruction might be appropriate. We can discuss that. But, again, fine with their establishing the fact that he was a DOJ employee. Any further questioning, and just kind of reacting to Mr. Skirek. Because we don't intend to push the issue or emphasize, feels a little wishy-washy. So we just wanted to bring it to the court's attention. If it goes down the path, we might object.
The court said, I want the parties to agree on the exact question that's going to be posed regarding this photograph. And I want you to instruct him that he is not to elaborate on his relationship with the Department of Justice.
Mr. Skirek said, Thank you, Your Honor. We will speak to the prosecution and agree on the question. Just to be clear. Again, I and the defense team do not have access to Mr. Higginbotham. I will do my best to communicate what Your Honor has just instructed to his lawyer before he testifies.
The court said, Anything further?
Ms. Murray said, Not from the government. Thank you.
The court said, All right. Please have the jurors brought out.
Jury present.
The court said, Please be seated. Good morning, jurors.
The jury said, Good morning.
The court said, It is 10:07, and I am sorry that I did not bring you out promptly at 9:30.
The interpreter said, We need some help here. I'm sorry. Your Honor, the witness is asking to test the device. May we test the device with him now?
Pause.
The court said, As I was saying, I'm sorry that I didn't get you out promptly at 9:30. There were a couple of issues. One issue is that juror number 10 has now been replaced by alternate number 1. In addition, I had to discuss some important legal matters with the attorneys, and so I am very mindful that you're waiting. And I don't want to waste your time. I know your time is important, so I apologize. I will try to keep that to a minimum. So now we're going to continue with the direct examination of Mr. Lai Dai. You may inquire.
Ms. Shrofa said, Thank you, Your Honor. Your Honor, perhaps the court would like to remind Mr. Dai he's still under oath.
The court said, Yes, that is a good idea. Sir, remember that you're still under oath.
Lai Dai, called as a witness by the defendant, having been previously duly sworn, testified as follows. Direct examination, continued, by Ms. Shrofa.
Good morning, Mr. Dai.
Good morning.
Mr. Dai, was the functionality of the HPay app in 2022 the same as that of what we saw in the video and pictures last week?
Yes, it is the same.
The interpreter said, Your Honor, I apologize. I'm having a device issue. I cannot hear him very well. Can you give me 1 second to switch my device? I apologize. I'm so sorry.
The court said, go ahead. All right, so we're having a failure here of the audio equipment. And we'll take a 5-minute break. Remember that you're not allowed to discuss the case amongst yourselves or with anyone else. Don't permit anyone to discuss the case in your presence. Don't read, listen to, or watch anything from any source concerning the subject matter of this case.
Jury not present.
The court said, we will recommence when the interpreter returns.
Recess. Continued on next page.
The court said, please have the jurors brought in.
The law clerk said, jury entering.
Jury present.
The court said, please be seated. Remember, sir, that you are still under oath. You may inquire.
By Ms. Schrofa.
Mr. Dai, was the functionality of HPay in 2022 the same as we saw in the videos and pictures last week?
Yes, the same.
Was the user experience of the HPay app in 2022 the same as we saw in those videos and pictures last week?
Yes, the same.
Was the functionality of the exchange's website in 2022 the same as we saw in the videos last week?
All functions are the same, however, 2 functions were restricted.
Mr. Dai, please try and answer my question, okay? Whatever restrictions there were is not. I'll withdraw that, Your Honor. Was the experience of the exchange's website in 2022 the same as those that we saw in the video last week?
Yes, the same.
Mr. Dai, what is the new federal state of China?
New federal state of China, it is to overthrow the CCP, to build the democracy and the rule of the law.
And it is to build a new regime in China.
When did you first hear about the new federal state of China?
The first time it was June 4, 2020.
Where were you when you heard it?
I was in Germany.
And how did you hear it?
I heard it from Mr. Gua's live stream that day.
Mr. Gua was with Mr. Steve Bannon in New York and announced the funding of the new federal state of China.
Was there anyone else on the broadcast?
Yes.
Who?
It should be other people who were in the live stream because they were in the boat on the ocean.
Mr. Dai, if you could listen to my question. Do you know if anybody else was present at the broadcast?
Mr. Horton said, objection, asked and answered.
The court said, sustained.
Did anyone else speak about the new federal state of China?
Mr. Horton said, asked and answered.
Ms. Schrofa said, he did not answer that question.
The court said, you may answer that question.
Everyone was discussing the new federal state of China, a lot of news media reported.
Who read the declaration of the new federal state of China?
Mr. Hao Haidong.
And who is that?
He was a famous soccer player in China. You can say that he was the Mr. Football in China.
Was his wife also part of the broadcast?
Mr. Horton said, objection.
The court said, was there anyone else on the broadcast?
Should be. I don't recall clearly.
All right.
Because it was long. During the broadcast live mainly were Mr. Gua, Steve Bannon, and Mr. Hao Haidong.
Mr. Dai, did there come a time that you became aware that the new federal state of China had a base?
Yes, I believe the earliest was 2020.
And what is your understanding of what the base was supposed to be?
The base will provide for member of new federal state of China and G-Club member a place for events.
They can live there for a period of time like a vacation. They can also host friends of new federal state of China, famous people, media, senators.
Mr. Horton said, objection. Move to strike for hearsay.
Ms. Schrofa said, that's his understanding, Your Honor.
The court said, overruled. Go ahead.
Also during the time of emergency, this place can provide help for G-Club members.
Did you learn if in fact a base had been found?
Mr. Horton said, objection, calls for hearsay, Your Honor. He has no personal knowledge. He's describing what he heard from other people.
The court said, if you'll step up, please.
Continued on next page. At the sidebar.
The court said, so aside from what he may have heard on a broadcast, did he personally have contact with the location?
Ms. Schrofa said, I don't believe that would be the testimony, Your Honor. But imagine if you're part of a member club. Say you're part of the Union Club or the Harvard Club. Are you going to really talk to the executive of the Harvard Club and each day he's going to call you and say, hey, listen, you know what, I'm going to put this new service in place, but all of you come to the executive meeting. And we'll all sit down and learn about this. And how else does one learn other than by listening to what the membership of the executive committee tells you is a benefit offered by a membership club? That's how you learn. That's the whole point of a membership club. We're not going to the truth of the matter asserted. They can say no such basis existed. But I note here again, Your Honor, 1. If you're a member of Netflix, the only way you're going to know what Netflix has to offer next is by looking at the Netflix website, of getting an advertisement, of getting a notification, and reading about it. That's the way it works. Netflix's CEO is not calling me to say, hey, you know what? This show is going to stream again tomorrow. Make sure you watch. And even that according to them would be hearsay, so how would a member know?
The court said, why can't he testify about what he heard on these broadcasts?
Mr. Horton said, because they're offering it for its truth, Your Honor. There's a difference between the Netflix member saying, well, the CEO told me that Netflix does X, Y, and Z. And as a member I use this service and this is my experience in using the service. He's not saying he went to the base. He's not saying he experienced it personally. He said I heard from other people what it was. They can call somebody who's at the base, who operated the base, who operated G clubs to testify from their personal knowledge, but this witness doesn't have personal knowledge.
The court said, so when the prosecution have witnesses on the stand and they ask them about all of the promised services and benefits, it was certainly not for their truth. The prosecution is not claiming that any of these services were offered, but my sense is that your witness is here in order to say that they did exist.
Mr. Kamraju said, I think there's a difference between saying that the statement is being offered in fact for something existing versus the topic is being discussed that it is something that people are addressing. It is something that members understand. It is something even the defendant understands. That's United States v. De Maria.
The court said, you're saying that you're not offering it for the truth?
Mr. Kamraju said, this is for their understanding, Your Honor. Whether they are right or wrong as to whether that was a base or not, it's a question of what they believed. And that's the question. It's an intent case. It's a fraud question. If we're not allowed to introduce evidence of statements, if we're not allowed to introduce evidence of understanding, then the only way that a fraud defendant can ever defend themselves is by taking the stand. Because otherwise, you're never going to be permitted. That's why you have a state of mind hearsay exception. That's why you have a present sense impression. That's why you have all of these exceptions. So we have no problem with any of this testimony with an instruction that says it's not being offered for the truth. Which that's the standard way that you deal with a hearsay issue. It is not to preclude the testimony in its entirety.
The court said, certainly this has come in already through other witnesses, hasn't it?
Mr. Horton said, the context matters for the hearsay rule, Your Honor. When we bring in something that the defendant or his agents or his co-conspirator says, the rule allows us to admit an opposing party's statements. What Mr. Kamraju was just talking about Miles Gua's intent, which we agree is the only intent that matters. This witness can't testify about Miles Gua's intent. The state of mind exception is about the declarant's state of mind. And Your Honor, we had a pre-trial argument about this a few weeks ago. This witness cannot testify. I heard this thing from somebody else, and so therefore it's Miles Gua's state of mind. That's not how it works.
Mr. Kamraju said, Mr. Horton is correct. The state of mind exception is not specific to the defendant. It's specific to a declarant. With respect to Mr. Gua's intent, it can be corroborated by independent evidence, including the understanding of other people. They're allowed to challenge that weight. They're allowed to challenge whether that's how significant the jury should afford that. Your Honor has already ruled that Mr. Gua's intent corroborated to be proven reasonable by objective evidence. The fact that they were being discussed is evidence.
The court said, so you're saying that you want to introduce Mr. Gua's statements. I don't understand how you get around the hearsay problem.
Mr. Kumraju said, "That's exactly what's in De Maria, Your Honor, and I have a copy of the case which I'll bring up." In De Maria, the facts of De Maria were, the defendant was present in a place to buy illegal cigarettes. It was either FBI or DHS agents, I don't know specifically, showed up and the defendant said, "Why are you guys here? I just came for some cheap cigarettes." And the prosecution moved to exclude that statement on hearsay grounds. The district court agreed with the exclusion on hearsay grounds. The Second Circuit reversed and called it wasn't harmless. Because what they said was, it goes to the state of the mind of the defendant, his then existing belief as to why he was there, which was relevant to the mind. And they also rejected arguments about it being a false exculpatory statement. About the exception swallowing the rule because the hearsay state of mind exception already has a carve-out in between. I can hand it up, Your Honor. That's the difference. We are allowed to say that Mr. Gua's statement, we're allowed to say that Mr. Gua's intent is provable by one of Mr. Gua's statements if it is a then existing statement of his mental state. And that's what De Maria says, and I have it here for Your Honor.
Mr. Horton said, Ms. Schroff's question wasn't about Mr. Gua's statements. The hearsay that the witness is testifying about wasn't attributed to anybody in particular. This case is about a defendant at a crime scene making a contemporaneous statement that comes in for his then existing state of mind. That's not what is happening here, Your Honor.
The court said, "Are you going to limit it to only Mr. Gua's statements?"
Ms. Schrofa said, "Sure."
Mr. Ferguson said, "That's not permissible."
The court said, "It seems to me that you're arguing they can bring in the defendant's statement?"
Mr. Horton said, "My point is that the case they're hinging all this onto a single parallel purpose." Mr. Ferguson wants to supplement what I said. I certainly didn't mean to suggest that they just bring in Mr. Gua's statements. It's fair game and hearsay, and what they're aiming for is not nearly that broad.
The court said, "I remember looking at this case and I don't recall interpreting it the way that you do, but I am going to take a second look at the case. So let us move on to something while my clerks will look at this."
Mr. Kumraju said, "Would Your Honor like the hard copy?"
The court said, "That's terrific. Thank you."
Mr. Kumraju said, "She's almost done at this point."
The court said, "We can always recall the witness if I don't come up with an answer soon enough."
Ms. Schrofa said, "That's fine. Whatever you want to do."
The court said, "Okay."
Continued on next page. In open court.
The court said, "You may continue."
By Ms. Schrofa.
Mr. Dai, let me show you what is marked not yet in evidence as Government Exhibit VD6. You could take a look at that document for me, please.
Mr. Horton said, "Your Honor, is there a question pending?"
Yes, I see it.
Are you done, Mr. Dai, reading the document?
Yes, I finish it.
Mr. Dai, do you recognize that document?
Before today, I haven't seen this before.
I couldn't hear him?
Before today I didn't see it. I didn't see it before.
Ms. Schrofa said, "I have no further questions at this time pending the court's ruling."
The court said, "Understood. All righty. Cross-examination."
Cross-examination. By Mr. Horton.
Good morning, Mr. Dai.
Good morning.
You're a supporter of Miles Gua, correct?
Yes.
You found him through his online videos, right?
Yes.
And you understood from watching Miles Gua's videos you thought he was a successful business person. Isn't that right?
Yes.
And when you met with Mr. Gua's lawyers earlier this year, you told them that you thought Miles Gua had a lot of credibility on investments, isn't that true?
To whom I met.
You met with Mr. Gua's lawyers earlier this year, do you remember that?
Yes, I told them that I like Mr. Gua's courage and his honesty.
The court said, "Sir, I want you to limit your answer to the question that's being asked. The answer that you just gave was not responsive to the question that was just asked. So I'm going to ask the reporter to read back the question, and you answer only the question that's been asked. I'm going to strike the answer."
The record was read.
Yes, I remember.
And you told Mr. Guo's lawyers that you thought Mr. Guo was credible when he spoke about investments, right?
Yes.
You believe Miles Guo when he talks about GTV, don't you?
You mean he mentioned GTV investment?
Yes. When Miles Guo talks about GTV investments, you believe what he's saying, don't you?
Yes, before my investment, I had not heard about GTV investment by Mr. Guo.
But then you heard him talk about it, and ever since you believed what he said, isn't that right?
No, I didn't hear him mention about GTV investment. Through the group.
The chat group of my fellow fighters, I got that information.
Well, but after that, Mr. Dai, didn't you exchange WhatsApp messages with Miles Guo about investing in GTV?
Ms. Strofa said, Your Honor, the witness testified he did so after the investment. The government should be clear.
Yes.
And after that you watched GTV for 5 hours a day, that was your testimony, right?
No, not like that. When I'm watching the video that was 5 hours a day, that was before.
Before I got information about investment. I started the information I got from the investment in May, late May 20th something. By then I already watched GTV for over a month.
But you heard Miles Guo talk about GTV stocks, for example, in his broadcast, for example, didn't you?
No. He has not mentioned anything GTV investment or stocks during his live stream.
Mr. Dai.
Therefore I learned this much later.
The court said, you need to stop answering. Once you've answered the question that Bin's asked, you just stop. So if I ask you what is today's date, you tell me today's date, but you don't also tell me what time it is. You understand? Go ahead.
Mr. Dai, over the last several years you've watched Miles Guo's live streams, haven't you?
Yes.
And on those live streams you heard Miles Guo talk about G Club, didn't you?
Yes.
And you heard on those live streams Miles Guo talk about the Himalaya exchange, isn't that right?
Yes.
Is it your testimony that on those live streams Miles Guo never talked about GTV stocks?
Ms. Strofa said, Your Honor, objection.
The court said, overruled. Overruled. Please answer.
G Club and Himalaya Exchange were all in 2020, after October of 2020. About GTV investment was from April.
And I learned this was May of 2020. So how could I learn about GTV investment by watching the other live stream on the other?
The court said, once again you have not answered the question. I'm going to ask the reporter to read the question back and only answer the question that has been asked.
The record was read.
Before my investment, no, he didn't mention that.
Mr. Dai, my question is. You testified that you've watched Miles Guo's live streams for the last several years. Over that period when you watched his live streams, isn't it true that Miles Guo talked about GTV shares?
Yes, he did mention that.
And you believed everything he said about it, isn't that true?
Yes.
And he talked about other investments as well, isn't that right?
Yes.
And you believed everything he said about those investments as well, isn't that true?
After I read the document, yes, I believe that.
And GTV, the G in that stands for Guo, isn't that right?
No.
The G in G clubs, that G stands for Guo, doesn't it?
No.
And the G in G fashion, that G stands for Guo, doesn't it?
No.
And the G in the G series investment that Miles Guo talked about in those broadcasts. That G stands for Guo, doesn't it?
To me I wouldn't say the G series, I wouldn't say that. I don't know what it represented.
Your testimony, Mr. Dai, is that after investing in GTV and in G clubs and in other G series investments, you don't know what the G stands for?
Ms. Strofa said, objection. That's not what he said. That misstates his answer completely.
The court said, you may answer.
The witness said, may I answer now?
The court said yes. Go right ahead.
I know what G means. It doesn't mean Guo. It means global.
Your testimony is that when Miles Guo promoted GTV, G Club, G Fashion and the G Series investments that G stood for global?
Ms. Shrofa said, asked and answered.
The court said, overruled. You may answer.
That's correct, it means global. This is very obvious. Can I explain?
The court said no. Go ahead.
You've heard of GUA Media, Mr. Dai, haven't you?
GUA Media, did you say? I've heard of it.
And the GUA in GUA Media, that refers to Miles GUA, right?
Or maybe, but he's not what you just mentioned earlier.
Mr. Dai, your testimony is that GUA in GUA Media only maybe refers to Miles GUA, is that right?
I don't know. I didn't invest in GUA Media.
I have never seen certain documents or explanation or description of what it means.
Okay. You heard Miles GUA talk in his broadcast about the Himalaya exchange, isn't that right?
Yes.
And when Miles GUA said that the Himalaya exchange is a cryptocurrency exchange, you believe that, right?
I heard this, but I believe the content is because when I read the relevant information.
At that point I couldn't decide it was true or not.
Well. You heard Miles GUA talk about the Himalaya exchange and H-coin and H-dollar on his live streams that you watched. Didn't you?
Yes.
And when Miles GUA talked about Himalaya coin or Himalaya dollar, you believe what he said on his broadcast that you watched, didn't you believe it?
No, I didn't believe that at the time. I was only interested.
Mr. Dai. It's your testimony that there were times when you heard Miles GUA talk about the Himalaya exchange and you did not believe what he was saying?
Correct.
And there were times that Miles GUA talked about GTV and you did not believe what he was saying?
Ms. Shrofa said, Your Honor.
I had no way to judge. I just heard some interesting information.
And then I was waiting to have more information come up in order for me to decide if that's true or should I believe it.
You agree with me, don't you, that H-coin is not backed by gold?
H-coin does not have gold as backup.
Right. And when Miles GUA said that it did, was he lying?
I don't believe he was lying. I was thinking that he was expressing his understanding of H-coin.
But obviously in the H-exchange in his white paper, he didn't specify that the H-coin was backed by gold. So I think the H-coin is independent platform so he can decide or design to decide how to do this cryptocurrency.
Mr. Dai, you agree with me, don't you, that Miles GUA designed H-coin?
I don't know.
Mr. Horton said, Ms. Loftus, can we pull up what's in evidence as GX9 and go to page 120? Mr. Dai, the Himalaya exchange launched on November 1, 2021, isn't that right?
Yes, the formal launch, yes.
On the screen in front of you there's a document called GX9, if you look at the top of this page. Mr. Dai. You see the date September 29, 2021, top left in highlight. Mr. Dai, the question is, do you see the date in the top left corner?
Yes, I see it.
By the way, G News, is your testimony that G News, the G doesn't stand for GUA either?
That obviously is not representing GUA. You can enlarge it.
Your testimony is that.
Ms. Shrofa said, Your Honor, may we ask for the document to be enlarged?
The court said, we haven't heard the question.
Ms. Shrofa said, the witness asked for the document to be enlarged.
The court said, absolutely it should be enlarged. Absolutely.
Mr. Dai, the G News.
As you can see, the G News.
The court said, one moment. You have to wait for the question in order to offer an answer.
Mr. Dai. The question is whether your testimony today is that the G in G News doesn't stand for GUA neither?
Does not represent Mr. GUA.
You see that this document is entitled Highlights of Miles GUA's live broadcast on September 29, 2021. Do you see that?
Yes, I can see the title.
And do you see Mr. GUA in the middle of the screenshot there on the top of the page?
Yes, I see it.
Thank you. Mr. Horton said, if you could zoom out, please, Ms. Loftus. Mr. GUA's statement on this date, Mr. Dai, September 29, 2021, that was just a few weeks before the Himalaya exchange launched. Isn't that right?
I think maybe over a month prior, yes.
And Mr. Gua says the safest virtual coin at the moment is the Himalaya coin because 20% of the value is anchored to gold. Do you see that right there?
Yes, I see that.
So when Mr. Gua said that was not true, was it?
Ms. Shrofa said, Your Honor, I have an objection under Federal Rule of Evidence 609, and if I need to elaborate, I'm happy to have a sidebar. 608, I'm sorry.
The court said, all right, let's have a sidebar.
Continued on next page. At the sidebar.
The court said, are you going to tell me about Mr. 608, Mr. Kamraju?
Mr. Kamraju said, I'm going to do that with another rule in combination, Your Honor. Rule 608 precludes specific instances of conduct being used to attack a witness's testimony. Basically, you cannot ask another witness whether somebody lied. And because Mr. Gua's statements are being offered for as an out-of-court declarant, he falls under those same rules.
The court said, so aren't you looking to impeach Mr. Gua essentially?
Mr. Ferguson said, the question was whether this statement that he just read was true. It doesn't bring up it's not character evidence under 608.
Mr. Kamraju said, it's 609b.
Mr. Horton said, Your Honor, I admit, I'm confused. This is a fraud case. What's at issue is whether Mr. Gua lied when talking about investments. The witness testified that he watched Mr. Gua's broadcast where he made statements about investments. The witness also testified H coin was not backed to gold. He agreed with me on that. Mr. Gua said repeatedly H coin is backed to gold. The question of this fraud case is, that's not true, right?
Mr. Kamraju said, you still can't ask a witness to impeach another witness's credibility in specific instances. Mr. Gua is an out-of-court declarant who can be impeached. It is a fraud case. They are allowed to prove that he lied. But the way you do that is not saying to one witness, did he lie on this instance?
Ms. Shrofa said, you cannot ask about specific instances.
Mr. Horton said, it cannot be the case that they can bring in a witness for the purpose of bolstering the credibility of Mr. Gua. Talking about materiality pro and con. And then we can't ask that this particular statement wasn't true based on the witness's prior testimony that H coin was in fact backed by gold.
Ms. Shrofa said, actually, the witness testified that he read the white paper, and that is what he relied on. He has repeatedly told you that he has not relied on Mr. Gua's video. You ignored all of his answers and you keep pummeling down this video road. And the rule has no exception to a fraud case. I think the statute is very clear. You may not ask about specific instances and ask somebody who is in court whether those are true or false. If the statute says, and by the way, we're making an exception in a fraud case, I would be delighted to hear that.
The court said, what's the other rule, Mr. Kamraju?
Mr. Kamraju said, if you give me a second. It's an impeachment of out-of-court declarant statements. I have to remember the rule number.
Mr. Ferguson said, if I may, Your Honor. I think just going back to sort of fundamental building blocks. This is a case about representations made to investors and whether they're true. That's not about there's no, like. The entire if Mr. Kamraju was correct. Then the government's entire case-in-chief was improper because we're impeaching an out-of-court declarant. Meaning the defendant. Of course in a fraud case you're going to say the things the defendant said are untrue. That's the entire basis for the prosecution. This rule, while it's sort of nuanced, it has no application here. And we're asking the witness if he agrees this representation was not factually true. That's the question pending. The objection should be overruled.
The court said, my recollection is the prosecution asked the same question of their witnesses. Why didn't you object then?
Mr. Kamraju said, I did.
The court said, why didn't you bring up the rule then?
Mr. Kamraju said, I did. I did, Your Honor, but I do think there is a difference and I want to draw this distinction. There's a difference between whether it's in a fraud case or any other case asking a witness for the underlying facts that show the defendant's statement is not true. They are undoubtedly permitted to do that. There's no bar to that. The point that I'm objecting to is asking the witness his opinion as to whether Mr. Guo lied in a specific instance. That is what the rule bars. This does not hamstring the Southern District of New York from bringing fraud cases in the future. They just have to do it consistent with the rules of evidence.
Mr. Ferguson said, that's not the question pending. The question pending is whether that factual representation is true. There's no reason the witness can't answer that, and I don't think Mr. Horton needs to ask. And Miles Guo was knowingly lying when he said that, right? He's not going to ask that. He can just ask, was this representation true, which is the question pending, and it should be overruled.
The court said, is there anything further?
Mr. Kamraju said, I just note, I don't think that was the question before. If that's going to be the question, that's a different answer.
The court said, my recollection is that that was the question.
Mr. Kamraju said, just so I understand the ruling, it's not that he can say did Miles Guo lie in that instance. He can say is that factual statement that Miles Guo said is true.
The court said, that's what he asked.
Mr. Kamraju said, I'm just making sure that I understand the court going down this road.
The court said, and you're not objecting to that question?
Mr. Kamraju said, I won't continue to.
The court said, I said you're not objecting to that question?
Ms. Shrofa said, we are.
The court said you are?
Mr. Kamraju said, to the factual predicate of his understanding if it's true.
The court said yes.
Mr. Kamraju said, I don't think I can object to that, Your Honor. I've made my objection.
The court said okay, if you can just hold on a second. I just want to talk to my clerk about the other issue.
Ms. Shrofa said, Your Honor. There was also a whole stream of questions that were asked prior to this one as to whether or not Mr. Guo had lied about specific instances. I didn't interrupt. But those questions are also improper to the extent they talk about specific instances that the witness is being asked about. And the record should be clear. The witness has repeatedly said he did not rely on the video in determining whether to invest. He said that over and over again.
The court said, did you ask questions that contain the word lie?
Ms. Shrofa said, yes.
Mr. Ferguson said, he did, and they were not objecting to. We're not going to keep asking those questions. We'll ask about factual representations, which is what was objected to, and I think is not objectionable.
The court said, wait one moment please.
Ms. Shrofa said, the question about him lying should be stricken.
The court said, wait a minute. I want to go back to the De Maria issue. I think that the defense is offering Mr. Guo's statement for the purposes of showing his state of mind. De Maria is different. It's a different circumstance where the defendant was saying something in the moment. So I'm not going to permit these questions about the location of the club, shall we say.
Mr. Kamraju said, just 2 points. You asked me previously about what rule I was citing in terms of attacking an out-of-court declarant's credibility. That's Rule 806, which says that the declarant's credibility may be attacked if supported by any evidence that would be admissible for those purposes if the declarant had testified as a witness. So it is subject to 608's limitations. And then the other thing I would say about De Maria, Your Honor, is I believe, I could be wrong, but I believe that that was not admitted as a present-sense impression. I believe that was admitted as a state-of-mind exception because the court specifically addressed the carve-out in that case and the distinguish other Second Circuit cases that had addressed the carve-out. So that case is certainly in my reading a state-of-mind case, not a present-sense impression case. So I suspect we are going to have this issue come up again. So I just wanted to flag that point because I think we're going to cite it again.
The court said, all righty. I'm not going to permit the statement with regard to the location.
Mr. Kamraju said, with this witness or with any questioning.
The court said, with this witness so far. I don't know what the others are going to talk about. They may say they visited the location. I don't know.
Mr. Kamraju said, understood.
Continued on next page. In open court.
The court said, "You may continue."
Mr. Horton said, "Thank you, Your Honor."
By Mr. Horton.
Mr. Dai, just redirecting your attention back to Mr. Gua's statement on the screen. Mr. Gua's statement on September 29, 2021. On G News that the safest virtual coin at the moment is the Himalaya coin because 20% of the value is anchored to gold. That statement was not true, was it?
You mean compared with the white paper from the H exchange, whether that's true? If that's the case.
That's not true because it's not linked to gold.
Right. Mr. Horton said, Ms. Loftus, can you scroll down, please, to the second paragraph on page 121. And, actually, if you could stop at the bottom of 120. You see the date on the left-hand side, October 20th, 2021?
Yes, I see it.
And that's just 12 days before the launch of the Himalaya exchange, correct?
Yes.
And that's Mr. Gua in the middle of the screenshot, isn't it?
Yes.
Mr. Horton said, Ms. Loftus, if you could scroll down to the excerpt. It's the second paragraph on this page. And highlight starting at, what is called the next 4 lines, please. Mr. Dai, on October 20th, 2021, Mr. Gua said, what is called? I am talking about your H coins. Brother 7 designed it at that time. Do you agree that Brother 7 is Miles Gua, correct?
Yes.
And so Miles Gua designed H coin, isn't that right?
Ms. Shrofa said, objection. Is he asking for his understanding, or is he asking what that document states?
Mr. Horton said, my question, Your Honor, to Mr. Dai is. Mr. Dai, didn't Miles Gua design H coin?
Ms. Shrofa said, objection. He has no personal knowledge.
The court said, you may answer.
At this place that says so, but I wasn't sure who was the real designer behind it.
Well, was Miles Gua, is this statement true what Miles Gua said?
Ms. Shrofa said, objection.
The court said, you may answer.
Ms. Shrofa said, we discussed this at the sidebar, and he also said he doesn't know.
The court said, you may answer.
Can you repeat your question because I was interrupted?
Is Miles Gua's statement that H coin has 20% gold and it is linked to gold, not the others? Clear gold directly. Is that statement true, Mr. Dai?
This particular sentence he did say that. He did say that sentence.
But it's not inconsistent with the white paper from the Himalaya exchange.
Mr. Dai, your testimony is that this statement is not inconsistent with the white paper?
That's correct, inconsistent.
Just so I make sure I understand, Mr. Dai, Mr. Gua's statement on October 20th, 2021 that H coin has 20% gold. Your testimony is that that is consistent or inconsistent with the white paper?
Inconsistent.
This statement on your screen from Miles Gua is not true, is it?
Ms. Shrofa said, objection, asked and answered.
The court said, he didn't answer. You can answer now.
This statement on your screen from Miles Gua, Mr. Dai, is not true, is it?
I believe that's his understanding of H coin.
It's not true, is it?
Ms. Shrofa said, objection, asked and answered.
Mr. Horton said, he did not answer the question.
The court said, the question was not answered. Sir, answer the question.
This statement, Mr. Dai, from Miles Gua is not true, isn't that right?
The content was not true, but I don't understand, do you mean to say?
The court said, I want you to answer exactly what is being asked. Is there something that you don't understand about the question?
The witness said, I understood the question.
He did say that. But if you ask me whether he said this thing, yes, he did say that.
Mr. Horton said, Your Honor, the government would move to strike the answer after, the content is not true.
Ms. Shrofa said, he answered the government's question.
The court said, what comes after the word true is stricken.
Last week, Mr. Dai, Ms. Shroff asked you some questions. Mr. Horton said, we can take this down please, Ms. Loftus. Ms. Schroff asked you some questions about, last week, whether buying a G Club membership would get you GTV stock. Do you remember that?
Yes, I remember.
And your testimony last week was that G Club and GTV seems not to be related at all. Do you remember testifying to that?
Yes, I remember.
Mr. Horton said, Ms. Loftus, can we show Mr. Dai what's in evidence as GX29 at page 113? That's Miles Guo in this screenshot, isn't it, Mr. Dai?
Yes.
And it's from July 30th, 2021. Do you see the date on the top left?
Yes, I see it.
And it's recorded on GTV, do you see that in the URL?
Yes.
And you watched GTV, isn't that right?
Yes.
Mr. Horton said, and, Ms. Loftus, can we scroll down to?
Ms. Schroff said, Your Honor, the government hasn't established that the witness has seen this particular video.
Mr. Horton said, it's in evidence.
Ms. Schroff said, that's not the question.
The court said, so I haven't heard a question, so I'd like to hear the question.
Mr. Horton said, if I could have, Ms. Loftus, scroll down to the right part of the document. It's the part that straddles 114 and 115.
The court said, I'm just realizing that it's 11:33, so it's time for the half-hour break. Remember, you're not permitted to discuss this case amongst yourselves. Don't permit anyone to discuss it in your presence. Don't read, listen to, or watch anything from any source that touches on the subject matter of this case.
The law clerk said, jury exiting.
Jury not present.
The court said, sir, you may step out. Don't discuss your testimony.
Continued on next page. Jury not present.
The court said, you may be seated. Is there anything before we reconvene at noon?
Mr. Horton said, very briefly from the government. Just before the break I didn't have a question pending. I don't believe Ms. Schroff made an objection. There was just an interruption and an assertion from Ms. Schroff. Just ask that she not be permitted to do that. She can make objections. She can wait for the court's rulings and she can follow them.
The court said, so you've been testifying, Ms. Schroff, as opposed to merely making objections. Don't do that.
Ms. Schroff said, yes, Your Honor. I do have a matter to raise, though. The government is purposely not asking the witness whether or not the document that is being shown is something that this witness ever saw before or ever looked at before or has even viewed before. It is consistently asked, could you sit down, Mr. Horton, so I may finish? Thank you.
The court said, whether someone is standing or sitting is up to me, Ms. Schroff.
Ms. Schroff said, I can't see.
The court said, don't be directing them what to do.
Ms. Schroff said, Your Honor, could I ask that the government not stand while I'm speaking cause I can't see? I'm rather short.
The court said, well, I can see you well. There's a space in between Mr. Horton and Mr. Ferguson, so limit yourself to purely legal issues.
Ms. Schroff said, I object to the way the government is asking the witness questions. The government is deliberately skipping the step of asking the witness whether or not the witness is ever seen this particular video before, or whether he's even heard it before. And what they're saying is, this is a document and evidence. And now read from it. Now tell me if what you're reading is true. That is what the government is doing. And that is why I have a continuing objection to the manner in which they're asking that question. Thank you, Your Honor.
Mr. Horton said, Your Honor, that's what redirect is for. There's no rule that says if a document is in evidence I need to establish some personal relationship from the witness to the document. The witness has also testified that he watched 5 hours of GTV a day.
Ms. Schroff said, Your Honor, that is exactly what Mr. Skirek did and what?
The court said, Ms. Schroff, don't speak over me. Mr. Horton has stated the law correctly. If you want to ask him on redirect whether he's looked at a document or video, you can do that. We'll return at noon.
Recess. Afternoon session 12:05 p.m.
The court said, please have the jurors brought in.
Jury present.
The court said, please be seated, and please continue with your inquiry.
Mr. Horton said, we're just awaiting the witness, your
witness present.
The court said, Sir, remember that you're still under honor. Oath.
Mr. Horton said, may I inquire?
The court said, yes, you may.
By Mr. Horton.
Mr. Dai, can you hear me okay?
Yes, I can hear you.
Before the break, I asked you whether you remembered testifying last week that G Club and GTV seems not to be related at all. Do you remember that?
Yes.
And if someone were to say that G Club and GTV were related, that would not be true, right?
But for my testimony, I was only talking about my fellow fighters.
And I didn't know what else you were talking about, no.
Mr. Horton said, Ms. Loftus, if we could please put up what's in evidence as GX9 at page 113. Do you see, Mr. Gua?
I was talking about a private, sorry.
The court said, so we don't have any question. So just wait for the question.
Do you see Mr. Gua in the screenshot here, Mr. Dai?
Yes.
And do you see this is from GTV? Do you see the URL on the left?
Yes, I can see.
Mr. Horton said, Ms. Loftus, can you go down to the bottom of 114 and the top of 115, please? You can scroll down just a few more lines, please. Oh, can we publish it to the jury, please? Can the jury see the screen? This is a statement of Miles Gua on July 30, 2021. Do you see that, Mr. Dai? Can you see the statement on the screen?
Yes, I can see.
There are still many people asking questions, Miles Gua said, including Brother Long Island. And you know who Brother Long Island is, Mr. Dai?
Yes, I know who Long Island Brother is.
He was the leader of the Himalaya Farm Alliance, right?
Yes.
In your answer to my question a moment ago, you referred to fellow fighters, isn't that right?
Yes.
Miles Gua says here in July 2021, there's still many people asking questions, including Brother Long Island. And Kai told me that some of the fellow fighters asked, will I still get a stock offer when I buy a G Club membership? And Miles Gua says 100%. Because I said that I have to promise that anyone who buys G Club membership before September 17th must be allotted shares. Which is exactly the same. Because we said that anyone can choose whether to use your money to buy G Club before September 17th. G Club and the stock shares. You'll get both. Do you see that, Mr. Dai?
Yes.
And you believe that Miles Gua tells the truth, don't you?
Ms. Strofa said, objection. Asked and answered several times.
The court said, I believe so. Sustained.
Last week, Mr. Dai, you were shown some screenshots and videos that you recorded before you testified. Do you remember that?
Yes, I do.
And Mr. Gua's lawyers asked you to make those recordings, didn't they?
I recorded.
And you recorded videos for Mr. Gua's lawyers of your HPay and Himalaya exchange accounts. Isn't that right?
Yes.
And earlier today, Ms. Schroff asked if all the features on your account were the same last week as they were in 2022, do you remember that?
I remember.
And you said under oath that 2 features were different, they were restricted. Do you remember that?
I remember.
And one of those restricted features was redemptions, wasn't it?
What do you mean by redemption?
You said that 2 features were not accessible to you in 2022, one of those features.
Ms. Strofa said, objection. That is not what he testified.
The court said, overruled.
One of those restricted features was redemptions, isn't that true?
When you say redemption, do you mean transfer HDO into US dollar to bank account?
Exactly right. That was one of the restricted features for some time, wasn't it?
Ms. Strofa said, objection to some time.
The court said, overruled.
Yes, the redemption amount went down.
Mr. Dai, you have a Twitter account, don't you? Mr. Horton said, I'm sorry, if the interpreter could read the answer please.
The court said, I'm waiting.
The interpreter said, do you want the interpreter reading?
Mr. Horton said, Mr. Dai answered it.
Yes, I do.
And you follow some cryptocurrency-related accounts, don't you?
Yes.
And you know that the Himalaya Exchange has a Twitter account, isn't that right?
Yes.
Do you know that while you were testifying last Wednesday, the Himalaya Exchange tweeted that its site was down for maintenance?
Ms. Shrofa said, objection. Hearsay.
The court said, overruled. You may answer.
This maintenance is too accurate and it will end shortly and goes back to normal.
It happened a few times before previously. It does not affect usage.
Mr. Dai, do you know that the Himalaya Exchange deleted that July 3rd tweet?
I don't know.
In between your testimony last week and your testimony today, there was a break in these proceedings. Do you remember that?
The interpreter said, interpreter repeat.
Did I rest? I rest.
And between your testimony last week and your testimony today, you met again with Miles Gua's lawyers. Isn't that right?
Yes.
You met with Ms. Shroff?
Yes.
You met with Mr. Skirik over there?
Yes.
You met with Mr. Barkin, who's not in the room, isn't that right?
Yes.
There are other lawyers for Miles Gua in those meetings, right?
I have.
This was after you started testifying last week, isn't that right?
Yes.
And Miles Gua's lawyers gave you advice on how to finish your testimony, isn't that right?
No, they did not give me advice.
Well, they talked to you about your testimony, didn't they?
Testimony. They asked me questions, I answered.
They gave you feedback on your answers, didn't they?
No, they mentioned that my voice was low last time.
Are you aware that today is July 8th, Mr. Dai?
I know.
You know that last night the Himalaya Exchange once again shut down for maintenance?
Yes, I know.
You want to help Miles Gua if you can, isn't that right, Mr. Dai?
Yes.
And you flew here from your home in Germany back on June 28th to try to help Mr. Gua, isn't that true?
Yes.
You've been here for almost 2 weeks now to try to help Mr. Gua, isn't that right?
Yes, 10 days.
And this morning, before you resumed your testimony, while you were sitting in that chair, Mr. Dai, and Miles Gua was sitting in the seat where he is in right now, Miles Gua looked at you and went like this. And nodded and smiled, isn't that right?
I did not see.
Your testimony under oath, Mr. Dai, is that earlier this morning, before you resumed your testimony, Miles Gua didn't look over to you, standing where he's now sitting, while you sat in that chair. And Miles Gua did not look at you and go like this?
I saw he smiled at me, but I did not see the hand gesture.
You still believe in Miles Gua, don't you, sir?
Yes, I believe him.
Mr. Horton said, Your Honor, if I could just have one moment, please.
The court said, okay.
Counsel conferred.
Mr. Horton said, Thank you. We have no further questions.
The court said, redirect.
Redirect examination. By Ms. Shrofa.
Mr. Dai, let me show you G9 that was. I'm sorry, apparently it's GXCC9 or Z9. Ms. Shrofa said, may I have the first part made bigger for him? Mr. Dai, you were asked questions about what the G stands for in G News, correct? By the government lawyer here?
Yes.
And your answer was interrupted, correct?
Mr. Horton said, Objection.
The court said, overruled. You can answer.
G stands for global.
Okay. Could I just point out your answer was interrupted, and you said it is obvious why the G is global. Do you remember saying that?
Mr. Horton said, Your Honor, objection. First part of the question was Ms. Shroff's testimony.
The court said, don't testify.
Do you remember saying that it's obvious?
Yes.
And could you tell the jury why it is obvious to you that G News stands for global news?
It was obviously from the design of the logo. This was the globe, it was a circle and its symbolic design.
Ms. Shrofa said, all right. So could we just
obviously represent global?
Ms. Shrofa said, could I have that blown up, please? Do you see Miles Gua's face in the middle of the G?
No.
Ms. Shrofa said, thank you, Jorge. You may take that down. Mr. Dai, when did you first hear about GTV?
Are you referring to the GTV media platform or the GTV private placement?
Let's start with the platform. When did you first learn about the platform?
April 2020.
And how about the private placement?
Whenever private placement information, that was May 2020.
And you remember being asked questions by the government lawyer about you listening to Miles Gua's videos about GTV?
I do.
Do you remember watching each and every one of Miles Gua's videos that mentions the words GTV?
Could you repeat the question?
The interpreter said, interpreter can repeat.
I cannot be certain if I remember all of them. But if I...
Are you finished, Mr. Dai, or are you still speaking?
The interpreter said, could you repeat your response one more time?
Ms. Shrofa said, I'll rephrase the question.
By Ms. Shrofa.
Mr. Dai, did you watch each and every video that Miles Gua ever made?
I cannot be certain, but I believe I saw most of it.
And before you invested through the private placement, had you seen each one of his GTV discussions on live broadcasts?
Before I finished the private placement, I did not saw Mr. Gua did the private placement live stream investment.
Did you read the private placement, all the accompanying documents, in English and in Mandarin?
Yes.
Mr. Dai, you were asked questions about the phrase, G-series, you recall that?
Yes.
Before today in court when the government lawyer used the phrase, G-series, had you ever used that phrase yourself?
I don't remember if I used this phrase.
Do you know what he meant when he asked you the question, G-series?
I know what it meant.
You were asked questions about Gua Media. Do you remember that?
Yes.
Did you invest in Gua Media?
No.
Did you research Gua Media?
No.
You were asked questions of the Himalaya Exchange, H-Pay, H-Coin, and H-Dollar, correct?
Yes.
And then you were asked questions about what happened to the exchange while you were actually testifying in court last week, correct?
Yes.
Do they allow you to bring your cell phone into this building?
No.
Do they allow you to bring a computer into this building?
No.
Is there any other way for you to check what is going on the Himalaya Exchange other than through the internet?
No.
When you invested in H-Pay, H-Coin, H-Dollar, and the Himalaya Exchange, did you read the white paper?
Yes, I did.
Have you ever reviewed that white paper with me?
No.
Have you reviewed that white paper with any lawyer from Mr. Gua's legal team?
No.
Between July 3rd or whenever it was that you last testified and here today, did anyone on the Gua team show you a single piece of paper?
No.
On July 4th, did we tell you to go watch the fireworks and celebrate Independence Day?
Mr. Horton said, objection.
The court said you may answer.
Yes, they told me that there were fireworks. And I went to the Brooklyn Bridge Park to saw the fireworks.
You were asked questions about Mr. Gua designing H-Coin, correct?
Yes.
And you said you did not believe that he designed it himself, correct?
I said I am not certain if he designed it.
And do you recall, sitting here today, if Mr. Gua talked about how he had consulted with professionals before the coin was designed?
Mr. Horton said, objection. Issue raised at sidebar.
The court said, sustained.
You were asked questions about having a Twitter account, correct?
Yes.
And on your Twitter account you follow Himalaya Exchange, correct?
Yes, I follow.
And do you think that Elon Musk's upgrading of Twitter is any less or more frequent than the ones being done on Himalaya Exchange?
Mr. Horton said, objection.
The court said, sustained.
You were asked questions about the two restrictions. Do you remember that?
Yes.
What are these two restrictions that you were talking about?
Redeem and top out cannot transfer US dollar into Himalaya Exchange to purchase.
And you want to convert the HDO into US dollar. The amount limit went down.
And when did the amount limit go down? What year?
I believe sometime in 2023.
So it was better in 2022, correct?
Mr. Horton said, objection, Your Honor.
The redemption amount was higher.
The court said, sustained.
The restriction was not in place in 2022, correct?
Mr. Horton said, objection. Mischaracterizes the testimony.
The court said, sustained.
In 2022, could you redeem more or less than in 2023?
More. At the time it was $100,000 limit redemption.
And what is it in 2023?
$5,000.
And you were asked questions, were you not, about statements made by Mr. Guo regarding the gold, correct? The gold package, correct?
Yes.
Did you take those statements into account while considering your decision in whether or not to purchase H coin or H dollar?
Those statement, that's not, in fact, my investment into Himalaya Exchange.
Why not?
Because I saw 1:1 ratio with a US dollar bonding. This ratio was good enough for me.
Mr. Dai, you were asked questions about you having flown all the way from Germany to come here to help Mr. Guo, correct?
Correct.
The testimony that you've given here last week and today, has it been truthful?
Truthful.
Has it been complete?
Complete. You mean did I tell everything?
Yes.
Yes, all that I know, I disclose.
And did any one of us tell you how to answer these questions?
No.
And other than me telling you to keep your voice up and enunciate, did I give you any other advice?
And as a matter of fact, I complained to Ms. Schroff about the headphone device.
And she tried to help me resolve this issue. And she wanted me to listen to the question clearly and tell the truth and speak up.
Mr. Dai, would you lie for Mr. Guo here today?
No.
Do you have a full-time job today?
Yes.
Do you have a wife and children?
Mr. Horton said, objection. Relevance. Scope.
The court said, sustained.
Ms. Schroff said, I have nothing further.
The court said, recross.
Mr. Horton said, we have nothing further, Your Honor.
The court said, thank you, sir. You may step out of the courtroom.
Witness excused.